Hi there and welcome back to our video series on recent data protection decisions from the Court of Justice of the European Union. Today I'm joined by my colleague Rory Curtis from the Technology and Innovation Department at Arthur Cox. So Rory, what will we be talking about today?
Yeah, so today we'll be looking at when regulatory authorities, other than data protection authorities, can have regard to a controller's compliance or non-compliance with GDPR, and also looking at the recent EDPB opinion on main establishment.
Okay, and the case we're going to be talking about is case C252/21, which involved Meta Platforms Ireland Limited and the German Federal Cartel Office, the Bundeskartellamt. Can you tell us about the facts of the case?
Yeah, so the case arose from the German National Competition Authority, which claimed that Meta had abused its dominant market position in relation to its data practices.
It's interesting that a national competition authority was looking at an entity's data processing practices.
Yeah, and this was the question that was referred to the CJEU. The CJEU was asked whether a national competition authority, which is not a data protection authority or a supervisory authority within the meaning of Article 51 GDPR, can determine whether a company's terms of use relating to data processing breach the GDPR when determining whether that company was abusing its dominant market position.
So what did the court decide then?
So the court said that the competition authority could have regard and could assess a controller's compliance with GDPR when assessing abuse of a dominant market position, but it said that in doing so it must comply with its duty of sincere cooperation with data protection authorities. So this means that it cannot depart from a decision of a national data protection authority, and also that it must consult and seek out the cooperation of the National Data Protection Authority in determining whether it has grounds to launch its own investigation.
Interesting. So what should controllers then bear in mind following this judgment?
So they should be aware that they may have to deal with regulators other than national supervisory authorities relating to data protection and their data processing activities.
And did the court take into account or consider what it might mean having a dominant position in the market in respect of obtaining a freely given valid consent under the GDPR?
Yeah, so at a high level, the court said that just because an operator of an online social network has a dominant position in the market does not mean that a user of that online social network cannot give a valid consent to the processing of their personal data by the operator. However, it did say that this would be a relevant factor in determining whether consent was validly or freely given, and that is for the operator to prove.
So let's move on then to the recent European Data Protection Board opinion on main establishment, which you mentioned at the beginning.
So this opinion is important because it clarifies certain matters on the main establishment, and it essentially says that the place of central administration will be the main establishment only where it can show that it is where the relevant decisions are taken with regard to the purposes and means of processing of personal data, and also that it has the power to implement those decisions.
Okay.
So unlike previous guidance from the EDPB on this issue, it does not state that there is a presumption that the entity with overall control is the decision-making centre with regard to the processing of personal data and is therefore the main establishment. This will be a starting point, but they need to show that, like I said, this is where the decisions are taken as to the purposes and means of processing, and the power is there to have those decisions implemented.
And did the opinion offer any practical considerations for controllers?
Yeah, so first of all, it said that the burden of proof is on the controller to determine that, or to demonstrate that the decisions are taken in a certain place and that the power to implement those decisions is located in that same place. And the EDPB said that, records of processing activities and privacy policies of the controller will be relevant in this assessment. They also said that the claims of the controller are subject to review by concerned supervisory authorities who can rebut the claims of the controller based on an objective assessment of the relevant facts and can require further information where necessary. The opinion also said that where the controller submits its claim and the supervisory authority decides there is sufficient or insufficient evidence for the main establishment claim, it should refer its conclusion to the other concerned supervisory authorities to facilitate an early agreement on the subject matter. And then finally, where the claim of the controller is accepted by the concerned supervisory authorities, the lead supervisory authority should notify the main establishment. On the other hand, if the main establishment claim is rebutted, this should be notified to the establishment, and the consequences of that decision should also be communicated. And then at last, where the concerned supervisory authorities cannot agree on the issue, then they may refer the matter to the EDPB.
Okay, great. Thanks very much for your time today, and thank you all very much for watching.